I hereby call this meeting of the Police Commission for the Town of Orangetown to order. Would the clerk please call the roll?
Councilman Dennis Troy.
Present.
Councilman Tom Devaney.
Here.
Councilman Paul Valentine.
Here.
Councilman Jerry Vitari.
Here.
Supervisor Chris Day.
Here. We're going to defer the Pledge of Allegiance to the regular meeting, which starts at 7:30. Tonight, we have the first of what will be several in the county hosted in the various towns. An information session for the public, and I'm glad to see several members of the public here, about the upcoming criminal justice reforms, if you want to call them that were passed by the state of New York in the budget last year as part of the omnibus bill. So these reforms kind of were starting to hit and people realizing them after the fact. And now you have everyone from State Attorney General Tish James down to even, I think de Blasio said something about it. There's a lot of concern. There's concern about the finances, yes, but more concern about the public safety aspect. So all the town supervisors, most of the mayors, all of our elected officials at the county level got together recently. We're trying to get word to our state reps that changes need to happen to this so it can work for all of the state, but especially our communities. I want to make clear from the start, this isn't a Republican or Democrat thing. You're going to hear from Republicans and Democrats on this issue. I'm going to welcome some elected officials, then I'll turn it over to Chief Butterworth, who will welcome other police officials, and each will have a couple of brief statements or explanations from various law enforcement officials. We may have time for a couple of questions from the public, but possibly not, but we will get all the information out at least, and then there'll be a chance to continue the discussion going forward. So I do want to welcome Sheriff Lou Falco. We have also incoming DA Tom Walsh, DA-elect, if you will. We have two representatives from the Village of Nyack Board, Marie Lorenzini and Louise Parker, as well as the village manager from Nyack, Jim Politti. Thank you for coming. And of course, the folks up here at the town board of the town of Orangetown are here as well. So I'm going to turn it over to Chief Butterworth, and go ahead.
Thank you, Supervisor, town board members, town clerk. Tonight's commission meeting, like you said, is going to be the first of numerous public meetings throughout the county regarding how law enforcement leaders in Rockland County believe the New York State criminal justice reforms that will go into effect on January 1 will affect our communities. I'm going to make a brief statement, then I'm going to have Police Chiefs Association of Rockland County President Chief Brad Wydell of Ramapo speak, and then Sheriff Louis Falco will speak on the position of the sheriff. Prosecutors when the criminal justice reform takes effect. That's offensive. I mean, we have our DA-elect here. I mean, they're sworn to uphold the law. They're chief law enforcement officers themselves. I think that's outrageous. Claiming that law enforcement professionals are using fear-mongering tactics and making outlandish claims that are not supported by evidence. Another thing that's kind of ridiculous because there is no evidence on how these things are going to turn out. We're just using our vast experience in law enforcement to guide this process through, and we're letting people know that this is one of the problems that's going. There's no evidence because some of these reforms are unheard of. They really are. This is such that a statement from the aide Kate Powers on behalf of New York State Attorney General Letitia James is that the challenges of complying with the new mandates are real, her words, and require investments in double-digit millions. So if these problems are real, it's not fear-mongering. These are realistic things, and this is somebody that is at the top level in this state of law enforcement. Other law enforcement officials, such as the head of the DA's Association of the State of New York, says this unfounded mandate will only cause victims to be victimized again when prosecutors are unable to perform the basic functions of their offices. That's a quote. Also, the Rensselaer County DA, Mary Pat Donnelly, they're playing roulette with public safety. Another one, the incoming NYPD Commissioner Dermot Shea is concerned at how these new reforms are going to affect keeping people safe. That's what this is all about, public safety. That's the business we're in. That's the business you're in. And the outgoing Commissioner of New York City Police Department says extreme criminal justice reform could unravel the hard-won gains, and it's only going to get worse. Again, his words. These are people just like the law enforcement leaders here tonight who have dedicated their professional lives to public safety, not people who are known to perpetuate false narratives and fear-mongering. This law enforcement community is not in any way against smart and justified criminal justice reform. I know in Rockland County, our mission is to help our communities and reduce fear. It is appalling that when it is believed that such extreme measures are needed, the people who have made these changes have sought no input from any in the criminal justice system that would be tasked with implementing these changes. They believe they are the experts and apparently have no interest in pausing this process with the goal of collaborative changes to our criminal justice system. I want to also be clear that our judges in Orangetown and the Nyack courts have always handled their duties with the highest standard of professionalism. And that's bail reform. That's basically a slap in the face of our judges and our district attorneys. I'm going to now welcome Ramapo Police Chief Brad Wydell, who is the president of the Police Chiefs Association of Rockland County. Thank you for coming tonight.
Good evening. Thank you for inviting me to speak on behalf of the Police Chiefs Association of Rockland County. The transformation about to take place to our system of justice is abrupt and dramatic. It is guaranteed to disrupt the system's equilibrium. These changes, in our opinion, will negatively impact public safety, especially the victims of crime and its witnesses. There are three areas I wish to address briefly tonight: discovery and its cost, mandatory release, and re-victimization. Please keep in mind that I'm just scratching the surface, and my comments in no way represent the true extent of the depth that this restructuring encompasses. The newly enacted 15-day discovery rule is not manageable. This rule requires that all materials, including reports, videos, audio tapes, notes, photographs, and lab results, be turned over to the defense within 15 days. I'm going to tell you right now, we already know that lab results take more than that to obtain. So how are we to comply with an unrealistic and impossible obligation? The reality for police departments in Rockland County is that we don't really have 15 days. Remember that this time frame includes getting all of the information that we have to put together and sending it to the district attorney for their review prior to them then releasing it to the defense. For us, it means that officers will be required to complete all arrest-related reports and that all supervisors will have to review and approve them prior to either of their shifts ending. There is no other way to compensate for this without incurring overtime. Costs are going to increase because staff must now be dedicated to calling reports, video, photos, as well as a host of other kinds of pieces of evidence, then prepare it in a package that can be electronically uploaded to the district attorney's office. This is labor intensive, and in the case of lengthy video, upload times can take hours. These changes will result in municipalities incurring substantial additional costs for personnel and equipment. It's unavoidable. Speaking for my department, as well as other departments in the county that I'm aware of, we've already budgeted significant supplementary overtime for 2020 just for paperwork completion. And unfortunately, the governor has made it clear that no funds from the state of New York will be provided to assist local government with these mandates. You're going to hear a lot about bail and pretrial detention, and what I will tell you is that it's eliminated in approximately 90% of the cases that we deal with. Even if a defendant has numerous felony arrests, misdemeanor convictions, felony convictions, failures to appear, the judge will no longer have discretion in the future to set bail. For virtually all misdemeanor and nonviolent felonies, both monetary bail and pretrial detention are eliminated. There's only a limited number of exceptions to this rule, some involving domestic violence cases, conspiracy to commit murder, criminal contempts involving domestic violence, and some limited sex offenses. For the violent felonies, money, bail, and detention are permitted, except for specific subcategories of violent felony offenses, such as burglary in the second degree, which is burglary of a dwelling, a home, or robbery, where somebody commits a robbery aided by another. Think about this. The burglar who burglarizes your home with your family in it is going to be released without bail shortly after an arrest. The robber who joins with another and robs you or your family will be released within a few hours of their arrest, all free to return and terrorize their victims or others within the day. Bail and detention are also going to be eliminated for every single drug felony, with the sole exception of operating as a major drug trafficker. In light of the massive opioid crisis facing our state, it is hard for us in law enforcement to reconcile that drug dealers arrested for Class A felonies are going to be released within a few hours of their arrest. Candidly, this goes for most violent crimes. It's been well documented that witness interference and witness intimidation are one of the biggest challenges we face in the criminal justice system today. Starting January 1st, witnesses already terrified by the defendant's criminal acts or gang affiliations will have their name, address, and phone number fully and immediately provided to the defendant under some perverse sense of justice. A defendant charged with a sexual assault could now depose a victim in a nauseating interview process. Further, they could petition the court to visit the scene of the crime, including the location where the act occurred. Whether for a sexual assault, a burglary, a robbery, a kidnapping, a general assault, I mean, you name it. Now the police are going to have to facilitate this visit back to the crime scene. This is insanity. To think that an officer who arrests a rapist or a burglar or a robber or a host of other violent offenders will have to stand by at the scene of the crime and to insist that the victim of this crime comply with the court's order to allow them access, it is highly offensive. It is a re-victimization of the original crime victim. But the worst part of it is that if the victim does not comply with the court's order, they, the victim, are subject to an arrest for contempt of court. That's not justice. I want to know what the people are going to think of our police officers who are placed in such an untenable situation. Our only hope in these cases is that our district attorney aggressively opposes any attempt by any defendant to return to the scene of a crime or to re-victimize people. Hopefully, our courts will side with the victims and the district attorney's position, but there's no guarantees. The precise effects of this law are hard to predict. Police departments across the county are working diligently to figure out how to adjust our policies and responses so as to ensure that we do comply with the law. Until our elected state officials acknowledge valid concerns and amend the worst provisions of this law, we're stuck with it. And we have a sworn obligation as police officers to uphold the law, and we will do our best to do so. What I would say to our state officials, our elected state officials, is although they may have voted yes for these reforms with the best of intention, they can no longer be oblivious to the consequences of them. On behalf of the Police Chiefs Association of Rockland County, I urge all of our state legislators to commit themselves to correcting the most dangerous and egregious parts of these reforms. Their focus must now be on restoring the rights and protections of those most deserving of our compassion and protection, and that's the innocent victims and witnesses of crime. I want to thank you for your time tonight. Thank you, Chief Butterworth, for inviting me.
Thank you.
Good evening, everyone. For those of you who don't know me, my name is Lou Falco. I'm the sheriff of the county. I just want to touch on a few things before I start this PowerPoint, and that is very simply listening to the words of Chief Wydell. We've had numerous police chiefs meetings and sheriff's meetings, not only in Rockland County, but around the state. As Supervisor Day said, we've met with every elected official. It knows no political boundary, whether it's Democrat, Republican, Independent, Conservative, it doesn't. The thing that's most alarming is it gets broken down into a couple things for us. One is an unfunded mandate. There's no financial way to subsidize all the police agencies, including the state police. We'll bring that into it because they're under the same restrictions. The Attorney General of the state of New York, our new DA walking in, being strapped with all of these things. But on top of it, you know, a few years back, the SAFE Act came into effect in New York State, and everything was about taking guns away from everybody and doing this and doing that. And you'll see in my presentation now, before it was an automatic arrest and you probably were bailed and went to jail if you brought a gun on school property. Now it's no longer, you're no longer going to be put in jail if you have a gun on school property. Prostitution on school property. And so you'll see what I'm going to refer to in my PowerPoint here tonight. And again, if we have time at the end, myself or the chiefs can take questions. That's great. I don't know what our time frame is going to be. So under the new law, over 400 crimes will require mandatory release. The thing I want to focus on here, drug dealers, house burglars, serial drunk drivers, and other lawbreakers will immediately be back on the streets to reoffend without any meaningful supervision. So, if somebody's DWI, they kill the driver in an oncoming car, no longer is aggravated vehicular homicide something you could take bail on. That person will be back out on the street if, in fact, they weren't either hurt in the accident or when they're released from the hospital, they're immediately back on the street.
We're not taking questions at this time, but maybe at the end if there is time. Thank you.
Effective January 1st, 2020, all forms of pre-arraignment bail will be abolished, and there will be restrictions on law enforcement detaining individuals pending arraignment. A new category of non-qualifying offenses will be governed under a new system of pretrial releases that will include only releases on ROR or the least restrictive non-monetary conditions. This, what you're seeing up there, you'll also see on the boards that are up in the front here. And the things that I want to really hit on that really will tie our hands and also hurt our children. And I have to tell you that that's very, very important to me. As everybody knows, the school shootings around the country, and everybody's putting police officers in schools. Criminal possession of a weapon on school grounds. Criminal possession of a controlled substance in the first and second degree. Criminal sale of controlled substance in the first. Even near school grounds, specific felony drug offenses involving the use of children, including the use of a child to commit a controlled substance offense. And we go on and on and on with all of these. Promoting a sexual performance by a child, hindering prosecution, tampering with a juror, or tampering with physical evidence, criminal possession of a weapon fourth, criminal sale of a firearm to a minor. No longer is it a bail offense. You're just automatically released after we get done with. We'll be in the station house doing our paperwork while that person is still out on the street. Aggravated cruelty to animals, over-dividing, torturing or injuring animals, animal fighting. These are some of the exceptions to the mandatory appearance ticket. An open warrant, failure to appear within 2 years, offenses needing an order of protection or DMV restriction, Article 130, that's the sex offenses, domestic violence, escape third, bail jumping second, individual needing court assistance for a medical issue.
That's the second bail jumping offense and the third escaping attempt.
That is
They have to
correct.
They try to jump bail twice
And
before
so,
they can get bail.
let me touch on that, because the sheriff's office is the one that extradites and investigates all the felony warrants after, in fact, they're arrested in the police departments, and if they're indicted, they don't show up for court. So, to your point, Mr. Day, I have to go to California and pick you up. I spend $7,000 or $10,000 of your taxpayer money to go and get that person, he or she. I bring them back, that person has to be released immediately. If now they abscond again and they go someplace else, I have to bring them back with your taxpayers' money, and they might be released a second time. So I could spend thousands of your dollars going to get people and bring them back with no consequence to that person, to your point. But in New York City, and if you want the articles, I'll show you, they're going to be giving out Mets tickets, gift cards to the defendants at their arraignment so they come back to court to answer their pleas.
Wouldn't Mets tickets prevent them from coming back?
Well, you notice that they didn't give them Yankee tickets. I see somebody wearing a Mets ticket and a Mets hat in the back.
I'm sorry, Mets are fine.
Okay, this means the court shall over ROR unless the court makes individualized determination of a flight risk. Factors relevant to the defendant's return to court, defendant's activity and history, defendant's charges, and on and on and on. The court may progress to a higher level of securing order only when a finding has been made with the court's explanation on the record or in writing. The defendant is entitled to counsel if cash bail is being requested. A bail review may be initiated arguing that the court did not use the least restrictive terms at every subsequent court appearance. Eliminated considerations for bail. And this is very important to every judge that's had the discretion and taken into account what he or she was faced with by the defendant and their past history. Cannot consider defendant's family ties and length of residency in the community or lack thereof. Cannot use the weight of the evidence. Cannot use the potential length of the sentence that may be imposed upon conviction. The court may no longer issue bench warrants immediately, must delay the issuance of a bench warrant for 48 hours. And I also believe that there's something in the law where the court clerks for each court has to make numerous attempts in that 48 hours to contact that person to ask them to come back to court, if I'm not mistaken. Additional reforms. This is where the real impact is to law enforcement, and where's our new district attorney? And to the district attorney. It's saying here on the second bullet, no more than 15 days after arraignment or any form or accusatory instrument, including felony complaints, must be turned over to the defense in 100% of the cases. This includes names and contact information of victims and witnesses. But let me just say this to you. For the district attorney, as I'm told by him in his office, for him to comply and us to comply, we have to get that there in less than 11 or 12 days. Because he has to have the right to go through it, be able to notify everybody, and get all of those things out. Now, if you go to the next bullet, previously, discovery took place in only 4% of the cases prior to these reforms. This is 100% of the cases. And here's it all gets compounded. If my cars are in the town of Haverstraw and they arrest somebody and a Haverstraw Town Police car comes and assists us, they have video cams in their car. Not only do we have to get all of our case records and send it to the DA's office, but now we have to contact the Haverstraw Police Department and say, did you have body cams? Did you have car cams? And we have to get that data and also extract it and send it on to the district attorney's office for he or she to evaluate. 2 minutes? I have to wrap this up because I guess we're coming to the end. But you can see the district attorneys in New York State said this is going to cost across the state about $100 million, and it's unfunded by the state of New York. Our Attorney General says, I support criminal justice reforms but the unfunded mandates is not being paid for, and she's going to have her own issues with that. Let me also say this, I guess on behalf of myself and all the chiefs here. No one's against reforms. Not everything that was done was wrong or bad in our opinion, but there are some things that are just over the top, and they're too severe for us to comply with them. And as the chief said, we can't get our drugs back from the state police lab in 15 days in order to make sure that they weren't, they're tested. So we go on and on with all kinds of restrictions. So on behalf of myself and the sheriffs around the state and the police chiefs, I thank you for this time.
Supervisor, I just want to get the DA-elect like 2 minutes to just address the group.
Yeah, Bruce, thank you.
Okay. And I also want to thank Chief Wilson for coming by and Captain Riley for coming by also.
Yes, thank you for joining us.
Good evening, and thank you for the opportunity. I know I only have a few moments, and let's talk about drug testing. 40 people in Rockland County in 2019 have died from overdoses. The New York State Police Lab cannot handle the volume of cases that will be presented. We have to stop the opioid crisis. We need to do that by effective prosecution. One of the unintended costs and consequences will be that we're going to have to reach out and undoubtedly get private labs at the taxpayer's expense to ensure that we can prosecute the cases and strike back at the opioid plague. The sheriff mentioned some statistics. I saw a report that in 2018, to give you real numbers, that over 2,700 arraignments were held. And I'm not telling you everybody went to jail who was arraigned, but I can tell you that between 89 and 90% of those 2,700 people must be released under the new bail reform. The third thing that was mentioned that I think is critical, if you happen to own property, the location of a crime, the defendant will have an opportunity to make an application to the court to go back and do a visit. Not only will that have consequences to law enforcement in terms of costs, but you're a homeowner. You don't want the burglar back in your house. You maybe receive notice, but who's going to pay for your lawyer if you want to go back in court and tell that judge, no, I don't want that person back in my house? And that's an unintended cost that anybody here that might be a victim of a crime, what are you going to do? You're going to let him back in your house? I think not. And I think that something should be done to defray the costs for the innocent people if the defendant wants to go back and see them. As said by the sheriff, many of these reforms are worthwhile, but they have to be funded. The 15 days is just too short a period of a time. It has to be extended. We also must make sure that we have protections for witnesses and victims of crime. It says the names have to be released and identifying information. In today's electronic age, give me your name, I'll find out where you live in a matter of hours. I think that we need to place the burden on the defendant for an articulable, factual basis why, far in advance of the trial, that they'll need the disclosure of certain witnesses and certain victims' names before the trial. I'm going to say thank you, Supervisor. I could go on and on. Thank you for the opportunity.
Thank you.
Thank you.
Okay, that's it from our presentation tonight.
Thank you, Chief. So we're running into the next meeting. What's going to happen is the police officials will be available in the rear, in the lobby, for take individual questions from members of the public who have questions. I want to wrap up this sort of information session just with a couple of points. This bill, again, no one is saying criminal justice reform is not needed. There are many things in New York's criminal justice system that needed reform, including cash bail system. What was done, and there's a reason it was tacked on to a budget bill, is that a bill that does not fix the system but breaks it is what passed. And what we're telling you, what our police officers are telling you, is that, and our DA and our sheriff, compliance with this law will make it less safe for residents and less safe for witnesses, and will cost an exorbitant sum of money to do so in a way that makes things less safe. And I think just a couple of brief examples. If someone was to produce child pornography and simultaneously fail to register as a sex offender after having already conducted a sexual act with a child, they'd be back on the streets the next day, regardless as to their risk of reoffense. If someone sold a gun to a child on a school grounds, that child had the gun on the property and then made a terroristic threat to their teacher, they'd be back in school the next day. If someone tortures animals, is running an animal fighting ring and torturing animals, they'll be back to supervise their business the next day. That is not the same thing as reforming a cash bail system. Our state representatives in this area voted for this bill. They also voted for the budget. We can't hold that against them. It was in the budget. It's already law. The only way we can get the changes needed to have a correct criminal justice reform is to have a hold on it when they first get into session. So we only have to deal with this system for the first week of January. It is law January 1st. January 8th, I believe, they're in session. So a moratorium on this bill, followed by a series of edits to it in the course of this session, in the way legislation should pass on its own, standing under its own weight, is what is appropriate. I ask everyone who lives in Orangetown to reach out to their state reps, to Senator Carlucci, to Assemblywoman Jaffe, and tell them, please, put a moratorium on it. Just hold it. Don't repeal it, just put a hold on it and see what could be fixed, since you didn't do the fixing before it became law. And the last thing is, this is going to have an impact the most in the most at-risk communities, in places that are poorer, that are higher minorities, because they are the folks that are going to witness the crime and then be intimidated by the person who is able to get away with tampering with a juror, hinder prosecution, and also resisting arrest. He can do all those things and still be free without bail and have the contact information of any witness. And the police will tell you it'll be very difficult to get witnesses to come forward in situations like that. So thank you all for coming. Thank you to the representatives of various police departments and to Sheriff Falco and to incoming DA Walsh. Does anyone have anything they want to add from the town board at this point? All right, so I'm going to move that we adjourn the police commission meeting. Is there a second?
Second.
All in favor?
Aye.
And again, there'll be availability for questions on a one-on-one basis in the back. Thank you very much. You can take questions in the back. Thank you.